That's a different matter. Promoters gives in a different manner. That's another aspect. But today also that happens. In resolution, what happens? Liquidation, everyone is losing. It's not a win-win situation. In CD, one thing that I can say that the most important aspect is that once the company gets either resolved or a liquidator, whatever the good assets of the company and whatever the productive asset of the company can be again put for productive manner. So that what happens, things will go on and things will work. However, in case of this specific aspect in the IBC, this is time-bound fashion, therefore productive assets, that is a good to economy per se. Economy will definitely be boosted up by that way because that productive assets will either it is taken over by somebody as a resolution or a liquidation. And ultimately, they start working in that asset. So today I have land, building, plant, and machinery which are not being used because of the fact that I am inefficient or I do not have adequate working capital or my financial position is not good. But tomorrow some good person with the financial muscle power comes and take up the company. These assets can be productive assets. That is the biggest advantage of the economy. Coming to the next aspects, who are other creditors indirectly affecting is the statutory dues. As of now, except the VAT of the Gujarat High Court, Rainbow Paper Mills Limited, judgment of that. Supreme Court stated that Gujarat VAT is having a priority. They are basically the secured creditors. When they are secured creditors, they have to be paid in pari passu with the secured creditors. So if you are giving 30% to secured creditors, VAT will also get 30%. They are giving 100% to secured creditors, VAT will get 100%. But what's about other dues, GST dues, income tax dues, custom dues? What happens with them? Service tax dues, excise dues. There you give meager money and get out of it because there is no requirement. So they are also losing a lot of money. Pre-IBC, the same situation was there. But I'll explain you that what are the best things in that eventually that we'll go to the next level. Here, workers, gratuity and provident funds and their salaries and employee salaries, they are not having a threat if you're going to the CR. They are going to get some pie out of it. Because nowadays, after Jet Airways decision of NCLAT, Provident Fund and gratuities are to be paid by even the successful resolution applicant, meaning thereby they are getting full money out of it. And salaries of the employees, particular workers, they are also on a pari passu basis, so they also get it. Only the key managerial person having a salary is more than that, they were not getting. Now, the liquidation and the IBC, what happens? If the company goes into liquidation, then an company is an IBC. The difference that one need to understand. Earlier act, when 1956 or 2013 act was going on, till 1st December 2016, prior to the IBC taking place. In the liquidation, yes, workers were getting the money, but that too after 10 years, 20 years, 30 years, look at the Ahmedabad textile mills. Lot of textile mills, lot of workers were there. They got money out of sale of the assets of the textile mill. But after 10 years, after 12 years, after 30 years, they got the money after a long time. That is directly impacting the overall recovery and the workers' inner strength of working because they have to just wait till the time the claims is to be given before the official liquidator. Official liquidator will approve. Prior to the approval, he will give it to some other chartered accountants to verify the claims. They have to give that all those aspects that I will give my affidavit and all, and then verify, and then okay, then High Court will pass the order, and then the money realizes I'll get pie out of it. Here in this case, at the time of resolution, they have to give me directly the provident fund and fully salaries also as a worker. So that they are winning in that eventuality. The another aspects which you can say that what the FCs can get it. FCs can just get other aspects from PUEF transaction, which was not there in the SICA Act. SICA Act, they were not allowing any PUF transaction that preferential or undervalued or a foreign, the transactions which are having extortionist or a fraudulent. So all these transactions for which you just get the audit done through a third party, transaction audits are taken place. Once transaction audit or a forensic audit takes place, you get the report. It is established that the companies are having this much PUEF transaction. The out of that, promoters were asked by the NCLT. Till so far, in number of cases, NCLT has given that these PUF transactions are valid, and therefore this money is to be paid by the CD or the, I mean, by the promoters to the either the FC. Normally, COC is getting that right, or at times the RA, successful resolution applicants, depends upon the resolution they do. But normally, COC keeps the rights with them and they get additional funds out of the PUF transaction. Their challenges are many. You have to establish that these PUEF transactions have been entered with a malafide intention, means you have to prove that. If the so therefore you have to also pay the money for the lawyers, give them clarity and understanding, and if lawyers can establish that these are the preferential or a extort shares or a undervalued transaction, they will be able to get it, or a fraudulent transaction. And that too also, again, now the promoters of the CD should have money. If they don't have money and if they go for the personal insolvency, again, then it's going to create a complication. But whosoever is benefited, not only the promoters, but if the benefited is the promoter's friend or promoter's other companies, even they will have to make the payment to them. So their refund will be the additional amount that they are getting. And FC can get also the additional money from the collateral secured the promoters or a corporate guarantors. Number of cases, the corporate guarantors against whom the CRP has been filed. Wherever the CRP has been filed against the corporate guarantor, it has been established that the corporate guarantor's assets are also being taken on the CRP. They are also, those corporate guarantor is considered to be a good company, having a good value, they will have to go to the CRP. They have no borrowings. They have adequate assets, everything. But once they have given a corporate guarantee, even they can come to the Section 7 and they have to pay for it. So this is another thing which is going to create a complication for the original promoters. When their other company has given a corporate guarantee, those corporate guarantee will also be directly or indirectly having realized by the FC. So this is another thing. So FC, if you look into the FC, they can get the money from the resolution. So whosoever successful resolution applicant, say assuming 40% of the claim that they are giving. Now the claim amount is, though they might have written off, they might not have put up the interest as their income, but they will give the claim up to the date of the CRP that this money that we are supposed to take up. So they'll take up the principal due plus the interest till the time the CRP starts. And then they say that this is a claim. So ultimately from that claims, even if 40% is there, they already written off more than 60, 70%. So there will be a profit in the books of accounts. B, they can get the money out of the PUEF transaction. Whatever the money that they need, for that they have to establish. That may take another 1, 2, 3 years, whatever the case may be. But if they establish it and the other persons have a capacity to make the payment, those who have taken the advantage, they will have to make the payment to them. So they get it. Thirdly, they get the money from the collateral securities of the promoters or a corporate guarantor. So ultimately, if you look into that, if such kind of the precautions have been taken by the financial creditor at the time of lending the money, then FC has a right to get much higher money than what was envisaged in the resolution plan. So this is the advantage of, and that too also with the time bound factor. So IBC is basically two things happens. Time value of money is taken place under the IBC. And time value of money is the most important part, because ultimately today if you have 100 rupees is much better than 110 rupees after 2 years, or 150 rupees after 10 years. So you have to understand that as early as you can realize the money, that money is considered to be good for you. So this is the most important part which one need to keep in mind, that financial creditors under the, when we talk about decoding of the financial implications in the IBC, we say that time-bound fashion has given a much better relief to the financial creditors. They can get their money unlocked within a specific period. The responsibility of the lender, particularly the lender team, reduces, in spite of the fact that nowadays a lot of agencies, government agencies are also directly, indirectly looking at such kind of the situation. Thirdly, they have a right, whatever the money that they cannot get, that for that they can go and for a personal guarantee also. Till so far, even this particular provision was not there. Personal guarantees, you cannot go against it, or if you go, it takes number of years to make the person insolvent. Or you have to just prove that person has given a guarantee and that he is not making the payment. Nowadays, that situation goes out. Once you have already revoked the guarantee, you have a right to go to Section 95 against the personal guarantor, even if you do not go for the CRP of a corporate. If the corporate debtor fails to make the payment, even then you can directly go and recover the money from the personal guarantor, which was not possible prior to the IBC. So in my view, this is a boon to the overall situation of the IBC, where financial creditor now can get the money and realize the money from personal guarantors. Either personal guarantors come for settlement, make some payment, and get rid of it. Or if you cannot make the settlement, then in that eventuality, he has to face consequences under Section 95. Only lacuna which I can feel like this as of now. Section 95 talks about that, yes, you can file a appeal against, I mean, you can petition against a personal guarantor. And if they can make the payment and the repayment plan is approved, then they will not be considered as insolvent and they're out from this. But if that is not happening, then what? They are not like the companies in case of the CIRP. If the resolution does not take place, automatically it will go to the liquidation. But in case of the personal guarantor, it is not an automatic that they will be declared as insolvent or they will be declared as out of this. They have no capacity of making payment. Again, either they will have to go or you have to go against making them insolvent. So once the repayment plan fails under Section 118, repayment plan fails in case of personal guarantors. Again, then you have to restart and you have to make a fresh application to make that he is now defaulter, is unable to make the payment, and he is considered to be the insolvent. That is a separate thing which you have to file another application. So this is, in my view, this particular aspect is required to be plugged in. This is a, in my view, this is a slightly small lacuna or a weakness of the IBC as of now, which is required to be added. Because in case of companies, when companies cannot be revived, or no resolution plan is approved under CIRP, automatically the liquidation starts. In personal guarantee, this is a small lacuna in my. So this is another thing which we need to understand, that whenever the financial creditors have a right to recover from the assets of the corporate debtor, not possible, then personal guarantors, not possible, then ultimately the collateral security is offered, not possible, then fully not available, then PUEF transaction, that preferential and fraudulent or extraneous or undervalue transaction, they can file, and whatever best they can recover, they can recover. In my view, let us have every 1 hour, let us try to have a 5 minutes break, so that what happens that you also come out with some kind of the questions. So this is, I believe it is a, sir, can we get a 5 minutes break right now? Can we make it like this?
Yeah, okay, sir.
Okay, 5 minutes, within which I'll come back.
Yes, sir.
Shall we start now? Sir? Am I audible?
Yes, sir.
Yes, sir. Audible.
So we were discussing about the implications on the financial guidance specifically. So three things which we have understood. A, financial guidance can get their money in time-bound fashion through a resolution or liquidation. B, as far as the banks are concerned, the responsibilities are being fixed by the government authorities like CBI, ED, or EOW. Those kind of the problems that they are out of it because it is through a entire court mechanism, and therefore IBC is considered to be much better than that of the recovery by themselves in an individual fashion. So that is the second aspect. Thirdly, after this specific CRP fails, then they have a right to recover the money through a personal guarantee, which was also prior to the IBC was very difficult. If you look at the uh, reports of the 2023 of the IBBI, which is considered the authenticate report, the personal guarantors against whom the total number of applications filed is 1,839. And in 28 applications have been withdrawn, 35 have been dismissed, RPs have been appointed in 760 cases. After appointment of RP, 11 applications have been withdrawn, 25 were dismissed, and ultimately number of cases admitted is 208. This is 31st March 2023 figures are there. So if you look at the personal guarantors also, now people have started taking, the financial guarantors have started taking the actions against them, and they have started getting the recovery. The first case which was also taken care of in Ahmedabad NCLT after the judgment of the Honorable Supreme Court in the case of the Anil Ambani versus the various banks. And once the personal guarantors, financial guarantors can go under the IBC, the Ahmedabad NCLT has already accepted the repayment plan. And in my view, the money is being paid against the repayment plan accordingly. In case of Mr. Karias or Pradeep overseas. So this is what I'm just trying to explain, that this situation has taken place. If you look at the CRP cases admitted as at 31st March 2023, so total number of cases wherein the resolutions have taken place is 678. Total admitted was 6571. Close was 4515 up to 31st March 23. Appeal, review, settle others is 959. Withdrawal under section 12A, meaning thereby the settlement takes place, is 848. Resolution plans approved as I said 678. Liquidation commenced 2030. So total approximately 2,708 cases on which the resolution or liquidation takes place, and ongoing CRPs at 31st March 23 was 2,056. Total time taken, average, 2670, 0 to 180 days, 8 cases, 181 to 270 days is 44 cases, 270 plus days is 626 cases, and average days is 614. So 614 days within which the CRP or liquidation took place and that case is resolved, meaning thereby on a period of 2 years from the date of commencement of the CRP, all the cases have been resolved. Average. Claims admitted. About 8,98,906 crores claims were admitted total. Out of that, APSIS claims have been admitted 8,11,805. And OCs were 87,851. These are the figures of the IBBI side. So I'm just mentioning these figures only to just give a clarity that what kind of the resolutions have taken place. So IBC is a boon to the APSIS. Out of the total 8,98,906, meaning there were 9 lakhs crores, total 9 lakh crore amount of the total claims. 8 lakhs 11,000 crore, 8 lakhs 8.11 lakhs crores were of the only APSI. meaning thereby it is more than 91% of the FC claims were admitted. And FC could realize money about 2.77 crore, 2,76,924 crores that they would. That is nothing but the recovery is approximately 34.14%. This is the authenticated figures of the IBBI, because IBBI gets the details and data from all the IPs, and from that they are just combining and just compiling the data. So authenticated data from the IBBI side, you can get it. In their annual report, they have mentioned that this much money that they can recover, 34.14%, it's considered to be a very good recovery. Only the claim admit out of the CD. So the additional money that they are going to get is from PUEF transaction, the additional money that they are going to get from the collateral securities, additional money that they can get it from the personal guarantees. So average recovery, if you look into the totality, about 50 to 60% in between that we can get it of their admitted claim. Meaning thereby, though they might have written off sizable money in the books of accounts because of the NPA norms of the RBI, they are getting more profit in their books, and accordingly, all the banks have started becoming much stronger in this case. So in this era, in my view, in next 1 or 2 years, the overall recovery to the banking sectors is considered to be very good, and according the profitability of the banking will go further. If you look at the OC's total claims which have been admitted was 87,851 crores up to 31st March 2023. Out of this, they could realize 9,136, meaning thereby 10.40% approximately recovery to them. Average recovery to both of them, OC and FC, is 31.82%. So average recovery is not bad. Liquidation value was 1,69,798 crores, against which they could recover 168.47%. So if you look at the total realizable is 2.86 crores against the liquidation value of 1.7 crores. So sizable money that they can recover. Otherwise, what happens? They are recovering 4-5% more than the liquidation value in case of a pre-IBC method. Here they got much better money either from the same promoters or from other resolution applicants. This shows that IBC is much effective, and the financial implications on specifically the FCs and OCs are much better in case of the IBC. Now, number of cases where less than liquidation is 150, and number of cases in BIFR not going concern resolution case is 54. Where liquidation the number of cases ending in liquidation is 2,030 days. So when if you look at the average liquidation cases, there are 456 days within which they have completed it. So 1.5 years the liquidation took place. And in liquidation, admitted, they are getting the money of 7% of the admitted claims. So what happens here, if you look into that, in liquidation, you are not getting more money, but in case of only the resolution, you get the good money. This is the sum and substance of the situation of the IBC. And if you look at the BIFR cases, time taken is more than 5 years, 7 years. B, the same promoters gives the plan. Here, you have a right to go to any successful resolution applicant. There is no requirement. Only the thing is that he or the company should be qualified in Section 29A. So this is a much better and transparent position. Everyone has a chance to give their plan. Everyone has a chance to find out that what can be the value of the company assets and the company, and whether they can take up to the next level or not. And if it is possible, then they have a right to give their plan. And if that plan is of highest value, they come in the highest in the matrix, that 90 days they pay or 180 days they pay, as per the metrics that they might be getting the chances, then the plan is accepted. And once the plan is accepted, I believe that the money, unlocked money, can be covered up by the all FCs. So this is the most important achievement which one can see. Now, if you look at the main cases, the 12 big cases the central government had come out. If you look at those 12 big cases like Electro Steels, Bhushan Steel, Monet Ispat, SR Steel, Alok Industries, those are the cases. If you look at those 12 cases, the government of India had come out. So in those cases, basically up to 31st 3 2023, if you look at the out of those, about 9 cases have been resolved by the by RA. Like if you look at SR Steel, as ArcelorMittal, Alok Industries, Reliance Industries out. So and JM Finance Consortium. Mono this part, their consortium JSW and Aon. Bhushan again, Bamnipal Steel. Electro Steel is Vedanta had taken over. So what is the more in Bhushan Power, JSW, MTech Auto, Deccan Value Investors. Jyoti Structures Group of HNI is led by Mr. Sharad Sanghi. JP Infrastructure Suraksha Realty Limited. And Lexlave Investment. So what happens here in this case, out of those 12 main cases where the government has insisted that to take them to CRP, about 9 cases have been taken care of in the resolution. On 31st March 2023, ERA Infra Engineering was under CRP. Lanco and ABG Shipyard were under liquidation. Means 2 companies went to liquidation out of 12, and about 9 were resolved. 1 was under the CRP. So if you look at this specific aspect, there they have recovered the money. The least money that they have realized is 17.11% in case of Alok Industries. The highest money that they got is 82.91% in case of SR Steel against the claim, and 88.22 in JP Infra, if you look into that. So total amount that they are recovering is much more than 40% as what 34% as envisaged in the average. So in my view, the IBC has given a good ground to everyone, including the original promoters, either to go for settlement with the bankers. If they give the settlement to the bankers, the FC gets that full money or whatever the haircut they want. This is a risk. But there also the problem was that if you go for the haircuts, the individual person will have some kind of a responsibility, and he will be asked for number of questions by the CBI or ED or EOW. In case of IBC, if it is resolved, they are out of this problem. So this is the one aspect. Secondly, under the IBC, anybody can take up the company who gives the more money. So there, FCs can get much better valuation. Thirdly, if the resolution, before resolution, if the promoters wants to settle, then in number of cases we have found out that they settle at the same money was they are supposed to pay. Only they, whatever the money that they have not charged interest, they only give haircuts or they are just get it. Otherwise, everything that they do, they restructure it or they do it, they will have to give the money, CDR they do, but ultimately the full money that they are getting. Because they know that he is afraid of the IBC, therefore let's try to take up the maximum. So this is another good thing that FC can get out of. So this is as per the resolution of financial service provider, which was basically started from 15th November as per the rules 2019. The 3 companies went there, basically Shrey Equipment, Shrey Infrastructure, Reliance Capital. These are the CRP admitted on 31st March. Diwan Housing, their Diwan Housing was taken over by the Piramal Capital. So if you look into the financial, so it was not there possible in SICA Act. Financial service providers cannot come because it is not an industry. Real estate not come because it's not an industry. So basically, whatever the loopholes or whatever the problems under the SICA Act were there have been plugged by the IBC, which has become a boon to the financial creditors, and they can get much higher, they can fetch much higher value than what they can realize otherwise. So this is an important development as what I understand. Let's go to the next level of the situation. The next is the, after that, if you look into that, is the financial implications to the investors. Now, there are 2 types of investor. One is the original investor who have invested money in the company. And the second is the new investors who is a resolution applicant or who is with the resolution. So I am talking first about the original investor. Original investor, if company goes in the CRP, then original investor is not going to get any money, because if it is being taken over by the resolution is made by some other person than the existing management, then nothing can get by. Then automatically it is gone, and any amount that you try to just work out during the resolution or liquidation is gone. So there is a potential loss of investment. Even if the promoter himself go and try and just complete that CRP, or new promoter comes and that he takes as a successful resolution applicant, then public shareholders will get minimum amount against the original investment, unless that money, that particular new SRA, the successful resolution applicant, takes the company to the new level, then only they can get a much higher return of their investment. Otherwise, they are not getting. Only 5% of the total public shareholders will remain. Slowly and gradually, another 20% new people will come. What happens? Alok, look at the Alok industry. The day on which it went to the CRP, the Alok industry shares were in the region of
जी नमस्कार
82.
मैं ठीक हूँ, आप कैसे हैं?
Sorry?
नहीं नहीं ठीक हो सर। नहीं नहीं
Any question?
आप ठीक आएंगे सर, थोड़ा खांसी सी हो रही है। हाँ बताइए सर।
In case of Alok industry, it was when the
27 की 15 हो गई।
sorry,
अच्छा बेटी हुई इसके। अच्छा आज ही हुई है।
sir, can you mute
मेल
yourself?
मेल तो नहीं आया कोई। आज 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 ही करा मेल क्या? अच्छा अच्छा अच्छा।
Sir, can you mute yourself?
अच्छा जी जी जी।
Sir, can you mute yourself?
अच्छा
Sir, mention the name, sir. Then only he realized, sir.
ठीक है, भेज दीजिए, कोई दिक्कत नहीं।
I think AKV. It is.
हाँ
the
मुझे
name of
देखा हुआ है, मेरा
AKV.
सर, मेरा देखा हुआ है। हाँ। अच्छा
Sir,
मैं
AKV.
24 डिस्पैच करना है ना, आज क्या हो गई? अच्छा 18 है ना?
Sir, your audio is on.
Yes, sir. So, if you look at Alok Industries shares, it was listed at 0.82 paisa or something like that when the CRP started. People have taken up the number of shares, that those who are aware that Reliance industry is immediate. And ultimately the shares goes to the next level and they minted more than 500,000% return in the Alok industry. That is possible, provided if the company continues the public shareholders as it is. Otherwise also, even if you take up the shares, then you may be in trouble, because the company, the new investors decides to, the SRA, successful resolution applicant, decides to delist it, your money goes. If they decide to continue with only 5%, your money remains only 5%. So if you have a 1 lakh shares, it becomes 20,000 shares. Then also there is no loss. I said, because 82 paisa or a 1 rupee 20,000 is not a, I mean, 1 lakh rupee you invested and today it is the 10 lakhs, your money is much safer or much better returns that you are getting. So that's possible. However, you need to understand that there may be chance that potential loss may come to your investments. Yes, there is an advantage. If I invested in some company which is now gone to the liquidation, and or there they decide, the promoters decide that there is not going to be any money remains to you and your shares become zero. In that case, if I have earned some money from other companies, long-term capital gain, then this loss I can adjust against that. So I can save my losses in taxation. So that is one need to also understand that. So that is another aspect which one need to find out. So this is the one aspect which every person will think about it, that once the company goes to the liquidation, then entire shares go zero, against which his any other long-term or a short-term capital gain, he can try to just set off against of that particular year, or as per the provisions of the Act. But this is required to be done immediately. Or if the public shareholders are reduced returns, as I said, if I've invested in ODN investments, today the returns I will lose. But if I feel like that Reliance or some good companies are taking over the shares of this company, or they are going to be successful resolution applicant, I will see to it, by hook or crook, I will take up the shares at a very low money, and then if that shares will come back, I can make the money out. So as I said, that capital is wiped off. Promoters can also take the deduction against their other capital gain. Convertible shares, convertible preference shares or convertible debentures, also losing their money even during CIP or liquidity, because they are also not going to get anything. Because when you are just in the acquisition, you have been given a convertible preference shares to be converted after 2 years or 3 years. Prior to that, the company goes to CRP, your money stuck. It cannot be converted from the preference share to equity. Ultimately, I'm in trouble. So these are the indirect implications for the original investors, I'm telling. Let's talk about the financial implications of insolvency professionals. What happens? Post IBC, the Insolvency and Bankruptcy Code had come up in 2016, December, for a period of 6 months. IBBI has come out that those practicing chartered accountant, company secretary, and cost accountants having an experience of more than 10 years in practice, they can immediately become IP for a temporary period of 6 months. And winning thereby or thereafter, if they give an examination, qualify themselves, the entire breed of IP started coming up. So IP is another profession which is coming up. I would like to say that this is a profession where good money you can get. However, you need to be very diligent, because otherwise, if you are just making any mistake, either the promoter, successful resolution applicant, COC, or unsuccessful resolution applicant can also put fingers against you. Because if you are making any mistake, forget that. It's not your mistake. This is error which is basically not done by consciously, but unconsciously you have made an error. But that error, if somebody grabs, automatically things goes out of your control and you will not be able to get any kind of the situation in that image. Then your entire money goes what? You will not be able to make the situation properly. So most important part is that insolvency professionals, yes, the fees that they are getting is better fees. They might be doing 2 or 3 or 5 assignments together. Going on, either they become an insolvency professional or a liquidator of a company or a personal guarantor. But their most important and the part is that they should be very, very clear in 3 aspects. A, all the procedures should be as per the books. You cannot go beyond the books. You cannot do anything of your own mind. B, you should know the industry properly, because you have to run the industry. You become a de facto a managing director of the company. And when you are running the industry, you're making any mistake, automatically you'll be in trouble. So if you don't know the industry or you don't know anything about it, you make it a complication. And third, and the most important, legally you should be competent. Legally, if you're not competent, then there are chances that at any point of time, any kind of the cases may come against you, your complaint before the IBBI takes place, and the money that you have earned, you have to spend much higher money. So your records have to be perfect. A, your legal criteria should be such that in any time you will not make any kind of mistake and you will be diligently doing the work for yourself. C, you should know the industry, or that you should learn the industry knowledge as well as how to run it. That because till the time the CRP goes on, the company should go on as a running concern, going concern basis, that you have to keep the company. So those kind of the knowledge you should have and you should apply for it. You should have a team of the people who take, because you might be at Delhi and your task is, say, not in proper Delhi, but somewhere 200 kilometers away from Delhi. You are in, say, Mumbai, but 300 kilometers away from that. You are habituated to remain in Mumbai on a daily basis. Now you are going to the company and taking care of it. So all those things you need to take. The distances are there. Situation is such that you will get a money, but not at the cost of your sleep, not at the cost of your other assignments. You need to have a proper team to build, see to it that no lapses, either the professional lapses or a legal lapses you should have. Otherwise, anybody can go and file a complaint against you, either in IBBA or NCLT, and you are always at the lower end. Recently, the IBBA has stated that in all the cases of the resolution or the liquidation where the main matters are going on, the IP or a liquidator should remain present during the course of the hearing. So now, third thing, though there is a clarity that you can come on the online platform, but your time will definitely be there. You need to remain present. And if any question comes from the lordship, you are supposed to give the answer to that. So you have to be agile, A. B, your entire procedure has to be within the framework of the law and copybook style. C, you should know how to draft your application and petition, whether it's a resolution or a liquidation. Your team of the lawyers should be good. The legal clarity to you should be there, as well as the legal clarity to the lawyer should be there. If everything goes in a hand-to-hand, I believe that IP is a good profession, where one can also make good money out of it. They are getting this is a new line which has come up, and they can get a good fees out of it. But three things that he has to understand. Fees has to be ratified by the COC on a regular basis. If the committee of creditors do not ratify the fees and you feel like that I will charge from the successful resolution applicant, he will not make the payment. Two, if the company is a going concern and the company is getting the money on a regular basis, you should recover the fees from the operations. Three, money should be availed in the form of checks or RTGS. You cannot take the money in the form of a share or a debenture or any other. These are the things which you need to understand. If you take up the money in other form, it's not also accepted by the IBPI. So one more line is developed for the insolvency professional, but the same one more agency has taken place to look at their vigilant IBBI. They will look into you. They will see to like IP. There is IPE is coming up. They are also getting good share. They have a proper team who can take care of your entire work. So generally and normally nowadays, when the IPE is there, you should attach to some IPE and try to get the work from them. And so that you do not make much mistake in completing your assignment and you get smaller share of the fees, but ultimately you will be also doing work on a consistent basis with the IPE. IPE gets money, IPA also gets the money. Insolvency professional agency like ICSI, ICI, three agencies are there. When they also get, but basically they are Section 8 companies normally. So they are not a profit-making company, but they try to just teach the IPs to see to it they go to the next level. They try to monitor and regulate the IPs. So they get the financial implications that yes, they get the fees, they get the out-of-pocket expenses, they get the money for the legal advices, everything they are going to get. But there also one need to be more careful. In so many large cases, it has happened that if I am a practicing chartered accountant, and if I am IP for a company, and if I try to give the assignment to my own firm for a transaction audit, then it is my interest where I have given to the firm where my interest, a lot of cases have taken place in past. I do not want to name, but then I will be suspended or I am losing my license, or I have to, what are the money that my firm has taken out of the transaction audit or other thing, my firm will have to make the payment back to them. So you need to be very, very careful that there has to be this IP is because old liquidators were there. like old liquidators were independent. They were employed with the the Ministry of Corporate Affairs. Like that, you are nothing but the officer of the court, and you need to, IPs will have to work in a professional manner with all clarities, papers work to be strengthened in a right fashion, and there cannot be any hanky-panky which should remain. You have to decide that. Otherwise, if in case of any loss or any paperwork which is not a proper paperwork you've done, or you made some mistake somewhere, you are directly entitled for the, making the, coming under the professional liabilities, and damages are to be paid. So this is also going to be a serious impact, because you are directly dealing with the money of some company where corporate debtor is not happy because the management is suspended immediately once you are appointed. COC is slightly unhappy with you because there is going to be a clash of interest, because every month you are taking, if the company is not working, you are taking some money from COC by their share. If the committee of creditors, 5 people are there, financial creditors, and everyone has equal share, and per month you are charging, say, 5 lakhs rupees, everyone have to deposit 1 lakh every month. So they are also getting some cheatery, because every month they have to pay, because they don't know when the assets are going to be realized. So they are also against you. Thirdly, successful resolution applicant. They, once you say that Mr. X is successful, but Mr. Y is unsuccessful, he may come against you. That this procedure, there is a lapse, this is a problem, something like that. Again, IBBI comes for the inspection on when they found out that there is kind of problem, they'll come anytime and this inspect your books of accounts. So you need to keep all the proper books and maintain as per the guidelines of IBI. Though you are getting financial implications while you get good money, you have to understand that whatever the earning that you have got should not be wiped off by some kind of your mistakes that you make. So I repeat and request in all IPs to tell that you have to be very careful while accepting the assignments. Thirdly, the most important part, assuming that some company where I was not neither named as IP and I'm not given my consent, but because that I am part of the NCLT, the IBA has given a list and NCLT has appointed me as IP. Now, this company, I have to see to that I should not have any kind of a clash of interest. If my brother was working there or my wife was working there, there's a clash of interest. Or I was working there and then I started working. I have to be very careful that this clash of interest, then I have to leave the assignment, let it be given to somebody else. I should not accept the assignment. I did the same thing in past also. So my humble request to all my friends that insolvency, as an insolvency professional, you can get good money either in the personal insolvency case or in case of the CIRP or a liquidation. However, you have to be so careful that there cannot be any fingers pointed against you by any of them. Then you will feel that there's yes, there is a return. Without risk, there is no return. Like Harshad Mehta used to say that ishq hai to risk hai. So you have to be careful on that aspect. But yes, you can do the needful in that image. Now, you need to have, as I said, that you need to have a discipline in that image. Both the discipline. In financial criteria should have their discipline. At the same point of time, you need to understand that as an IP, I should also remain in my limit. If I make some mistakes, if I require, say, consultant for GST, I have to keep a consultant for the company's CEO, GST consultant. If I require the management might not require because they might be good at GST or they might be good at income tax, they might be doing in-house. But now, if I am IP, I have to take a decision that I don't want to take any chance. If something comes under the reverse mechanism charge or direct mechanism charge, I don't know. So why should I take risks? So I need to have some additional consultant. If I have to hire some company secretary, look after the company's return to be filed, I have to do that. Because as the IP, it is my responsibility to see to it that I file the returns on a timely basis. Once I am appointed as the IP or RP or in a CIRP. So these are the things which one need to be very careful and cautious. If you make any kind of the difficulties, so wherever the experts advice require, feel free to go to experts, take the advice for the company, try to say the company to just pay for it, but ultimately you should remain aloof from that. Don't and should see to it that you should not have any kind of a professional interest in that consultant or expert or advice. This is the most important thing that you need to understand. Resolving insolvency in a timely manner is enhancing the investor's confidence. Let me put it like that. Now we talk about the new investor. So far we have understood is the old investors. Now when we say about the old investors, you can find out that the new investors, what happens with the new investors? New investors is nothing but a successful financial resolution applicant. When we talk about successful resolution applicant or SRA, what happens in that eventuality? He is interested in resolving it in a time-bound manner. If you try to do it over and above the time-bound, nobody is interested. Because see what happens in last couple of years after the IBC started. We have seen that today I am a successful resolution applicant and I have already filed my bid with the COC. I have adequate net worth, I have adequate amount to pay within time-bound manner. Now what happens? Let me just mention very clearly. COC has agreed that I am a successful resolution applicant, I am SRA. They accepted my plan. My plan now has been put up for vote and vote is 100% in my favor. It went to the NCLT. NCLT, at the time of NCLT, the unsuccessful bidder, unsuccessful SRA, unsuccessful resolution applicant will come before the NCLT and start saying that these are the problems and the entire procedure which has been taken care of is not in a transparent manner. He may say that. Like what today people are saying about the EVM. They are not working properly. Anyway, I'm not trying to compare this, but people say that if I'm losing the election, I say EVM is not proper. If I am winning the election, the EVM is good. So like that, if I'm losing that particular resolution, I will say that is not a transparent manner. And therefore, I will be against the insolvency professional or against the CEO. Assuming that NCLT passes the plan after 2, 3, 4, 5 hearings. Again, it will go to the, so this 180 days completed. After that it start or 270 days completed. So now these days will not be taken into account for the purpose of considering the CRP. Look at this, again lacuna. Legal battle, whatever happens, say they accept that and then somebody goes and to the NCLAT, the original promoters, because original promoters are also be hurt because they are losing their assets at no value. And when they are losing their assets, they will definitely ask the question that why so? I have to be very careful on that. I will not allow this. And therefore, at that point of time, he will also go before the NCLAT or he may go to the NCLAT. If he loses, he will go to the Supreme. So what happens is that time goes. Like look at this recently XIII. Successful resolution applicant had given 150 crore rupees by way of a guarantee. NCLT, then he went because time went and then he said that give me more time for the payment because there are chances that the SRS financial position also may take some small kind of a different curve. Original situation, today's situation may change because the time will. I was thinking that within 6 months I have to pay, I have money. But within that time goes to 12 months or 18 months or 24 months within which I have invested somewhere and I am unable to get that money out of it, I am in trouble. XIII, SRA could not make the payment. Ultimately, NCLAT has agreed for the time enhancement, but the Supreme Court stated that once COC has accepted the plan, nobody has a right, and the NCLT has already passed the plan. Nobody has right to make any changes in the plan. Therefore, that 150 crore fully is now the company went to liquidation. 150 crore paid by the SRA by way of a guarantee. Guarantee was involved, 150 crore taken by the liquidator, and now will be distributed to secured and other creditors. So what happens in that eventuality? You are out of that money. This is Jet Airways decision is going to be a very, very unique decision. Jet Airways has given a lot of landmark judgments to us as far as the, what you call it as a IBC is concerned, wherein they stated that PF money, Inclate has stated that PF money of Jet Airways Maintenance Association will have to be paid fully by the SRA also. Gratuity also they have to pay over and above the plan. This is something which was not written in IBC, but yes, the decision is final. Similarly, in the case of what you call it as a this, that if I have committed 1,000 crores in any plan and if I pay 150 crore rupees right now, I have to understand that 850 crore I should keep aside till the time plan is not. Otherwise, I may lose 150 crores. Though today I am SRA, tomorrow it's possible that somebody goes to the court and then it may take 6 to 8 months or 12 months time, within which if I should have that points available with me. If that point is not available, I may lose my 150 crore also. So on the one hand, I try to take up the assets at a lower good money, and I thought that my investment is much better. But then on the other end, I may end up in just losing even 150 crores. So I have to be very careful in that opportunity that as the SRA, I have to be clear that the fund which committed should be kept aside. However, the SRA, till so far, whatever the resolution has taken place, it has been found out that SRA gets the assets or the CD at a very reasonable price. Why? Higher than liquidation value, but lower than the realizable value. Two things happens. Till so far, if you look into the totality, the first and foremost thing, the goodwill is not being valued because the company goes to CRP, people don't try to tuck up. But yes, in some of the cases, some of the business goodwill is required to be valued. That is the additional advantage to SRA. And second advantage is of a contingent assets. What happens? Infrastructure companies there, they have, say up to, assuming today we are in 2024, 2017, 18, the company was doing good. They have paid taxes, but there are certain taxes of say 100 crore liability took place in the company. Thereafter, the company started making losses, but infrastructure company, you know that every time there is some percentage which is being taken as a TDS by the income tax department. So my TDS is about 40-50 crore rupees due with the income tax department. They have not adjusted. And then I went to the company went to the CIR. So now income tax department cannot adjust. As a successful resolution applicant, I have given a plan. Assuming the value of the assets was say 40 crores, I have given a plan of 42 crore or 45 crores. Liquidation value is 40 crores, 45 crores I have given a plan accepted by the COC. Now in that I have mentioned that I am paying 5 lakhs rupees towards the statutory dues, that is income tax, GST, etc. The entire cases against company should be null and void and zero. However, if any amount of refund which I am supposed to take, that the company is entitled to after the plan as a successful resolution applicant. Now look at what happens. This is a contingent assets. 30 crore rupees was originally due as a TDS lying with the department. They have not adjusted against my 100 crore liability. So 30 crore remains separately. 100 crore liability becomes zero, after making 5 lakhs rupees payment. Now this 30 crore along with the interest that I'm asking for. So as a resolution applicant, I am saying that 30 crore plus say 2 days 10 crore is total this. So 40 crores I am entitled. I have given a plan of 42 crores where the assets value except this, because it's a contingent asset. Nobody knows that this is going to come or not. Therefore, it was not valued neither by the valuer, financial assets valuer, or by any other valuer. So this is never valued. Now I'm asking for it. Government is entitled to give 40 crores to me I have given a plan of 42 crores and against which 40 crores I'm getting from the income tax department after the plan is approved. What happens? I'm taking the money at only 2 crores. This is the most important part which one need to understand, that what kind of the situation people are trying to take their advantage. Because these contingent assets are never being valued anywhere. And therefore, if your plan is properly drafted, you have a right to take up that contingent assets and you can get those money with you. So this is the advantage to the SRA. This is what one need to understand. The most important part, what happens? In case of commencement of the greenfield project, meaning thereby, if I have to just, I am a person who is an investor, I have adequate money and I have experience. But if I have to start with a scratch, land purchase, building, permissions, then machineries purchase and everything I have to go, then it takes long time for me to get the commencement of the production one more time. I have to go to the building permissions. So everything, 100 permissions I have to take up. So all those things will take time. Well, in case of the SRA, successful resolution applicant, he can say that for a period of 6 months, all the permissions which were become already expired will remain there. And thereafter, I will go for the new, and then he can immediately start the production by spending, making some overall thing of the machineries and some small capital expenditure, within which he can start the production of the company. Or if the production is going concern, if the working capital is a problem, he can infuse the working capital and production can be started. So he can start production. This is nothing but a kind of brownfield project, not a greenfield project. Greenfield project means the project which is to be started from a scrap. And brownfield means if actually I go for merger or acquisition, if I try to acquire some company in other version, I have to pay more money. In SR, if I become an SRA, I have to pay the value of the assets and not the goodwill, not the business, anything. Automatically I start, and if somebody knows that I am a good person, having a good name in the market, I can get the immediate credit and immediate customers can start working with me and I don't have any problem. So I can commence my business immediately upon getting the possession of the sale. Now, what happens if I am there as a SRA with my acumen, and if I am from the similar line, or if I have adequate experience in the same line of the business or CD, I can make it profitably within a very short time. So this is the advantage to the SRA. Understand this point. So if you look at the BIFR, means pre-IBC and post-IBC period. Pre-IBC period, BIFR, generally the company remains with the CD only, because it was always in the corporate debtors control, and thereafter also they give the scheme is approved, and for 6-7 years, then ultimately then they come. But they do, the promoters may not be having adequate capacity to run it. Therefore, the company having a productive assets cannot be profitable in a short-term way. In case of this, it is open for everyone. If the promoters are qualified, they can give it. Qualified as Section 29A of the IBC. If they are not qualified, any other person can give and get the plan. So in that case, the plant can be run up because we have seen that so many companies have huge assets. Number of products are there, but due to the non-availability of working capital, non-availability of adequate technical people, or certain wrong decisions taken by the promoters, the plans cannot be worked. So machines are new, not utilized properly. So new SRA has a lot of advantage in that. He can immediately start working. He can work out a solution immediately to see to it that he can commence the production and make it profitable. Provided he should have adequate means, experience, and people. Three things are required, and the market. So what happens if I have adequate finance, I can put up the working capital adequate and start working in that dimension. So this is the advantage to the successful resolution applicant. What happens here in this case? I would like to say slightly in a lighter fashion, if I'll say that, what is the difference between the pre-IBC and post-IBC period? Pre-IBC period was like how now the people are trying to just find out that if a person is going a marriageable age, and if he goes and just find out that through a marriage bureau and just get the groom or a bride. So that is a one way. Then he has a limited selection. In IBC, I would like to say it's like in case of the old regime, when the kingdoms were there, Swayamvar was going on, that 100 kings were coming for the princess. And ultimately, the princess decides that to whom she wants. Like that, we know that the Draupadi Swayamvar, Arjun came and then she picked up. So because of that particular, so here also it happens. 100 people will come. Whosoever is a good, have a right thing, he can get the factory, he can get the company on a going concern basis. Now the another advantage that SRA has. Up to 2023 and thereafter the post-regime, let me put it like this. But prior to 2023, Section 28(4) was of the Income Tax Act was not amended. Section 28(4) of the Income Tax Act is now amended. So prior to that, what happened? Prior to that, whatever my term loans payments were there, I used to directly write off to the capital reserve. I was never taking it to the profit and loss account and not showing it as a profit. So what happens? I need not to pay any tax on the haircuts that I'm getting. Now what happens? 28(4) says that any credit you get amended after the amendment of the 23 Act, that is considered to be your income. So now it is not possible. Earlier it was possible that you were just getting the losses carried forward and the haircuts, you were directly taking it from the profit and loss account and you are able to get. So ultimately, this is also contingent asset. Let me put it. The company is having a 400 crore losses and 200 crore depreciation on them. So 600 crore rupees. I, as a successful resolution applicant, can get the advantage of that 400 crore and 200 crore also. Provided if I have taken it before 2023, where I have right to not to take it through a profit and loss account and no tax on that. So that was another which was never being valued by any valuer. So if I have to, I am in a 30% bracket or 25% bracket, then 600 crore into 25 crore percent that I am getting about 150 crore additional money. One has to understand that this is also an additional income or additional asset to the successful resolution applicant. This is what we need to understand. Again, now look at the mergers and acquisition and look at the IBC. As per the Indian laws, if I take any company on an acquisition basis or a merger basis, what happens? I have to enter into a proper shareholders agreement stating that any liability of the past will come that will be taken care of by the older promoters. Because I am taking it on a running concern business, but where I am making all these points very clear, shareholders proper agreement takes place. I am taking, say, I am putting 10 crore rupees aside and will pay at the end of that 100 crore assets I am taking or 100 crore acquisition I am taking over. There we have a proper signing, 90 crore I am paying, 10 crore I am keeping. And assuming there is no liability coming in 2 or 3 or 5 years, I have to make the payment of 10 crores. That will remain in a escrow account. Now what happens IBC? I'm reading from all the clutches. IBC says that whatever the past liability is not mine. So successful resolution applicant has an advantage. In the merger or in the acquisition, if it tries to take it tries to acquire the shares of that company through the M&A procedure. Chances are there 10 crore, even 50 crore liability may come. You never know. Some cases are going on, or some case started that you infringe some particular patent or a trademark, and that will commence, and then sizable money you have to pay. But that is of old money. I mean, you have a escrow account 10 crore only. What about another 20, 30 crore rupees that you have to pay extra? It's your risk. Here in this case, there is no risk. Once you have taken any assets under the CIRP on a going concern basis, your entire past liability, you have to draft your plan properly. asking for the total relief and concession, stating that any amount of the past liabilities or past cases are considered to be zero as of date and nothing remains against the CD. So do go to the old promoters, don't come to the CD. CD is out, new promoters are also absolved from all the liabilities. So this is a clean slate that you are getting. This is a clean slate, and which meaning thereby you do not have any tax with you and you are debt free then. If you make the payment to your traders, you are out of this. So this is the most important situation where I can say that IBC is having an advantage over the all other aspects. So that one need to have a control. So what is important for you is that in case of an acquisition, it will not that old liabilities become zero, but in case of IBC, yes, your old any additional liabilities against you, either through operational creditor or through statutory liabilities or a financial creditors, companies is absolved from that. That is an advantage. No legal matters remains against me. My entire legal cases against the company goes out. If you look at the judgment of the NCLAT, look at that customs authorities have fast let's seize certain assets of the company because or seize the accounts of the company. But IBC is overriding clause, and that has stated that judgment has come up that the customs have no right over the IBC. IBC is overriding over the custom. So I am absolved. Whatever remains with the old promoters, that is none of my lookout. I am out of it. I am having a much better situation. So in my view, if I have an option of getting any assets in the plan, vis-a-vis the acquisition, I would love to take the assets in the plan or a corporate debtor in the plan instead of the acquisition, because there I'm absolving from all the liabilities as a company, and I do not have any past tax with me as far as the liabilities or cases are concerned. In case of the acquisition, that kind of liberty I do. So that is the most important to SR. As I stated that certain contingent assets that from government department can also be available, which can be added as a part of the kitty, like the losses, carried for losses, or a credit in the GST account. Normally, people do the day on which you are in CRP, nobody is valuing that. These are the valuations which one can take. Again, the SRA can say that PUF transactions, any money which will come to me. So any amount which is required to be recovered under the preferentials or undervalued or extraordinary or fraudulent transactions, if I have taken a company in 100 crore rupees, but that kind of a 20 crore rupees additional comes to me, I have to pay 2 crores by way of expenditure. That's always going to be much better for me that I'm getting at least 18 crores against that. Now, these are basically the advantage of the SRA. And in SRA, if you are an investor, I was telling you the two types of investor. One investor, the original investor in the company. Now the SRA, I am an investor. I am also going to get a good advantage out of it. Because as I said, that 95% of the equity I can get, only 5, even it's a public listed company. So what happens? The another platform contingent asset that you are getting is, you need not to go to the public for that matter. You need not to go and list your company. Because for listing the company, you need to have a lot of SLs to go, NSC, BSC, and this original company was registered with the NSC, BSC. My company is automatically, means as a SRA, I'm getting it. I'm merging that company with me or me with them, paying the debts, coming out of this. So I'm good to go with that. Losses I can set off against my profit also, or this company's future profit. So that is also one good thing. Now 95% of the shares of that company with me, only 5% of the public shareholders. Now further 20% I can raise out of the public. So making total 75%. So in that eventuality, I am at a much, much better advantage. I can get all sorts of the advantages under the resolution plan instead of that. Look at the even the government has also made necessary changes in the Income Tax Act, that those who are taking the companies under the resolution, and there is a change of more than 51% shareholding under the IBC, then it will not be treated as change in the IBC. So there also you are having an advantage that though you are changing the shareholding, it will not be treated that all past losses will not be less and you are entitled for the losses in that venture. So this is an advantage to the resolution applicant. So the successful resolution applicant and your investor to that successful resolution applicant, you are always having an advantage. Thirdly, any other asset, say for example, I am going out of all the claims against me, means any liability which may occur against the company, I am going out of it. But there may be some kind of land in the city had a land in Mumbai, and the government had acquired at say 100 rupees per square yard, a square meter. But that case is going on in the High Court, and High Court has now stated that instead of 100 rupees, you have to pay compensation per square meter 1,000 rupees. There was 1 lakh square meter land. It is already sold, not with me because government is already acquired. But now I'm getting 900 into 1 lakh square meter. So that is an additional contingent asset that I'm getting as a successful resolution applicant. So these are the hidden money which are there, which I'm getting. In Mumbai also there are a lot of, in real estate, what happens? That there are a lot of persons who have started working in that real estate projects also, where they take up some kind of I have a FSI, I have a certain specific FSI and I have to purchase the FSI from somebody. So this company has a FSI, CDF, they can sell it. It is not never valued and they get the money. So these are the contingent assets not valued by the valuer, which is required to be taken into account. And the successful resolution applicant will have to look into that, how many assets you are getting. You are getting a direct assets, you are getting a contingent assets, you are not getting any liabilities, you are getting a contingent asset in the form of the listing also, you are getting contingent asset in the form of the GST credits or a past losses in the form of income tax or a MAT credit, as the case may be. So these assets will come to you directly and will definitely take you to the next level. So overall, if you look into that, things which I need to mention is, you are always going to be in advantage if you are a part of the successful resolution applicant investor. Subject to the fact that you need to do your homework properly. You have to decide that when the bidding takes place, you do it at the right price. Negotiation takes place with the COC, you have to give it a right price. Do not go beyond a particular, do not go lesser than that. Don't try to be over greedy or don't try to be over the spending also. That I want to take it by hook or crook, that should not be the case also. Provided a right price, if you get, you should go and take up that CD. So this is what as a SRA you do. Now coming back to the pre and post IBC financial implications, if we look into that, as I said that real estate companies, they were unable to go to SICA, the BIFR, because they were not industrial undertaking, and therefore there was an indirect disadvantage to them. Now any company can go at any point of time for the purpose of this BIFR, this after the IBC. If you look at the recent case, which is decided on 23rd October 24 in the Supreme Court, in case of the GLS Trust Company LLC versus Baiju, Ravindra and others, there also, they sets guidelines for withdrawal and settlement of IBC cases under Section 12A. Adhered with regulation 30 of the CRP regulation. You can withdraw. Applications will be moved through resolution profession only. You cannot do it just like that. That me and the creditors have settled, then I just go and just settle it. And it's not possible. It has to be even Article 142. If you have to just take up Rule 11 of NCLT rules, everything has to be said. The Supreme Court has made a clear guidelines that even if the settlement takes place under Section 12A, it has to be through a resolution profession and not by the parties. So these are the things which are more important. Like, say, Baiju or any IT company can never go to the BIFR at that point of time. In post IBC, yes, now they've started doing it. See, basically, the problem, the tech companies, what the problems are there, or the companies with having a goodwills are there. The goodwills are most perishable assets. In BIFR, what happens? It takes 6 months, 6 years, 12 years. We don't know. By the time the goodwill is totally gone. In case of the IBC, your goodwill, because if you can complete within 6 months or 12 months, goodwill will remain with you, and you can definitely get that as an asset. Another thing, the Honorable Supreme Court has stated that you have to withdraw the insolvency cases under the 4 stages. And they have already prescribed the procedures under the existing framework. A, before the application is admitted by the NCLT, Section 7, 9, or 10. 10 is out of question, but 7 and 9, if you look into, that if it is admitted by NCLT, before that you can just go and file that and you're out. Second, as you are aware that COC is to be constituted within a specific 21 days to 30 days, you are supposed to have a COC and meeting should be taken place once you are appointed IRP. So Section 7 or 9 or 10 application you have made, prior to that you can, before the COC is constituted, you can come and just settle and just, then there is no problem. You can work out a solution. So here it is settlement takes place and there is no problem. However, once the COC is constituted and expression of interest has been issued, then application is first of all is to be put before the COC for voting. With 90%, only can submit the application to NCLT. And the NCLT has to apply their mind and decide about what is the situation. Last and final. After an application under, in the third stage is that the UI is not issued. Once the UI is also issued, application is admitted, COC is formed, and UI is issued. Then what happens? Then you are supposed to give the proper reasons for the withdrawal at a belated stage. Why right now you have come? So Supreme Court has given a proper guidelines and framework stating that at what place. So as RP, as I was talking to you, that RP has to be more careful about each and every aspects. All cases of the Supreme Court, which are the landmark cases, should be known to him, or he should take a proper guidance from his lawyer or legal team, mentioning that what are the things that he can do. I believe there is a small goof up technology, and therefore everyone was just out for 1 minute. but it has restarted again. So my only basic questions are that RP has to be very careful on that. Now, as the time is also passed a lot, let me just say that any questions that you have. So let's have a question answer sessions to make it more interactive. If you have any questions on this, that financial implications in the deconstitution as compared to the earlier act, except the promoters. But all other agencies are having a much better situation as of now in the pre-IBC regime. So if you have any, just if you feel like that it's a longer question, you may write down in the chat box also. If you have anything to say or add, that it's try to work out, because 5 o'clock has already been there. I've only taken 5 minutes break, and thereafter be continuing since last 2.5 hours. So you're not able, I'm not able to get that. Any questions, sir? Anybody wants to ask any questions with respect to the decoding of the IBC in the case of the finance? Any questions, sir?
No, can I ask one general question?
Yes, sir. Yes, sir. You are.
No, IPE, how is going to benefit for IPs?
Two things takes place. If you're only IP, see, nowadays, I'm sure that you must be aware that the IP is nothing but is a kind of a partnership or a private limited company having a 4, 5, 10 IPs available to them, right? Now, what happens whenever the case, so that the IP is going to go and take a lot of cases for you in the case of, because they have got a good clout with all these financial creditors or operational creditors, and they try to work out that. That is number one. They always say that XYZ IPE and Mr. So-and-so is a responsible person. So you are a responsible person as IP.
Yeah.
But the entire work shall be taken care of by everyone. You are responsible, but ultimately, because originally it was only the IP was only a part of it in getting more money. Nowadays, what happens? They have to work, they have to give the name also. So once the name is given, say tomorrow something happens to you, and if professional liability comes, even they are equally responsible. A. B. Their entire team will be available to you for two things. A, to get the cases, and to also support you on legal and all other professional aspects. So overall, what happens? You can get more cases. B, you will be, say for example, you are a part of the partnership or a LLP or a private limited company of that IPE, you will get pie of somebody else with you, and you have to share your pie with them. So these are the indirect or direct advantages. So in my view, the IP gets, say for example, you are getting 100 rupees, IP get 50 rupees and you get 50. So that 50 rupees goes to them. That today you feel that 50, but your work is 50% or less than that. Your responsibility also goes down because of the fact that they have batteries of lawyers, batteries of experts, and they maintain all kinds of the minutes and everything. At the same point of time, somebody gets that 50 rupees is a basic pie where they're after expenditure 30 is a profit. You are getting also there, you are 10% or 20% partner, you get that 30 rupees, and somebody is also getting, you are getting. So overall, your work will be enhanced and you get some money more. So that is, in my view, that is going to be better for IPs.
Thank
Sir,
you,
first
sir.
of all, you have to got an assignment from IBC, then you will go to for IPE. Yes, sir.
Sir, there are two ways of it. One is that you are already a part of the IPE, right?
No, sir. If
Because
I'm not
assuming that
going
I am a,
partner of that IPE, then what to do? As
I'm just telling you.
I've got an assignment.
Sir, two things. Correct. There are two ways. One is that you are an independent IP and now you are searching for IP. And second is that
Okay.
you are already registered with the IP and IP gets the assignment in their name and you are a responsible person. Those two situations are there. The first situation I have explained
Right,
is
right,
the second one, right? Now you are IP and now thereafter you find out some IPE. Then in my view, if I would have been there, I would also stated to the COC as well as to everyone that it's IP and I am a responsible person. Decide about the proper work allocation as well as the fees allocation. And the money, assuming the 100 rupees I have decided, say 30 rupees goes to IPE, I will say that directly COC will pay, or CD or whatever will pay 30% to the IPE and 70% to me. So what happens at that point of time? The responsibilities are fixed, liability is fixed, work is fixed. You have to enter into a proper agreement, and once you're satisfied with them, you go for the next work with them. Otherwise, forget.
Right, sir. Your point is also it is right, but normally it is a matter of fact that whenever you got an assignment as an independent IP, and after getting the huge, uh, say you got an CRP from big company, then you are not independent IP, can't manage this everything. Then you have to go to any IP or anything else consultant. Then they will discuss about your fees. Normally,
Sir,
50%, 60% they will get.
yes, I
After that,
agree with you.
you will have to get this amount.
The two things happen. See, normally nowadays, even the COC or the bankers have also understood that if the bigger case are there, they would like to go through IPE only.
IP has, not independent IP, right?
Individual IP, they do not go. So
They do
there,
not go.
see, prior to 2 years, 3 years, situation was different. Nowadays, they know that because if they have a batteries of the professionals who can work, assuming that one IP expired, the second person can be responsible for that, and ultimately the CRP takes place smoothly or liquidation takes whatever it comes. So basic intention on their part is that now the bankers also, the financial institutions also takes the IPE and then responsible IP. That is happening. If you have a big assignment nowadays, that will not happen. But if you go that, yes, then you discuss that, then if you get 50 or 60%, let it be minutized directly right from that, and also minutize that these are the works that you should have proper allocation of work between you and them. So that tomorrow, if IBBI comes, you should have a very clear situation that these are the work that they have taken care of. This is the work which I have taken. They are not only for taking the sharing the fees. They are also supposed to responsible for work also.
Yes, sir. Sir, one
Though you are
question.
ultimately liable, but overall, yes, sir. Yes, sir. Sir, go on, please ask.
Sir, one question is that normally one statement usually coming from here and there, the bankers are more interested in surfaces than IBC. Is it true?
No, sir. Sir, let me tell you that depends
Yes,
upon the cases to case. Let me tell you. If it is a, see, what is happening, if they are only single
Means surface
lenders,
of the surface
they
it
may try
is
to, yeah. But if they are having a consortium or a multiple banking, they try to
okay.
go for a, see, what is happening that, and that too, since how much NPA is there. If the recent NPA, things are different. If the NPA is there for more than 3 or 4 or 5 years, then even IBC is better for them also, because the fact that there will not be any liability fixed to a particular person. Because 5 years prior to that, I have not lended. Somebody has lended. Some lapses from somebody is there, then why should I be held responsible? So here in this case, CBI comes and it comes to me also. So normally the bankers try to, if you make them aware that if you go through the IBC, your responsibility will not be there. So normally in case of a consortium or a multiple banking finance, they try to go through IPC. In case of sole financing, they try to go through SERPIS.
Yes, sir. That is much more speedy than IBC.
Correct. Correct.
That is much more speedy than IBC.
But subject to, see, there also the promoter can go to DRT and DRAT and then High Court and then Supreme Court, right?
Right.
Here, simple NCLT, NCLT and Supreme Court. And that also, they know that IBC case is very fast disposal. So that the speedy will not be there. So depends upon the amount involved, depends upon the time with it, since last so many years that company is in NPA, all those things they look into and then decide about it. And how the promoter is litigated, that is also important.
Okay, sir. Now, State Bank of India stating that they are NPA less than 1% nowadays.
Yes.
So that
because
is
of the fact that they reduce, either they have sold to the ARC or they have gone for SERPIS or they have gone for IBC. So things have changed also.
Right. But
Any more questions to anybody? Yes, sir. Sorry.
नहीं सर ठीक है ओके सर
So any questions to anybody? Thank you very much to everyone for patience listening to this particular session. And I thank the Anjali Gupta ji and the ICSI IPA for inviting me for this specific session, which is considered to be the forte because I have done my doctorate in financial restructuring after appearing before BIF or AIF for a number of times. And thereafter, I am appearing before NCLT on a regular basis. So I could see that the difference between the post and pre-IBC era, what kind of financial implications that has taken place. Thank you very much to everyone. Sir, thank you.
Thank you, sir. Thank you.
Thank you.
Good session, sir.
Thank you.
Thank you, sir. Thank you, sir. Thank you for sharing your experience.
Thank you so much.